The books are about the ideology of transgenderism being imposed by a framework of federal, state and territory laws that have replaced the inherent rights based on sex-based rights, with newly created rights based on a person's fluid gender identity. These laws attack freedom of religion, belief, conscience and speech, and threaten a person's employment for expressing and manifesting their belief that humans are immutably male or female. If I could adapt a recent statement of Augusto, Lorraine Finlay and Joshua Forrester into a question, would amending the existing anti-discrimination laws so that they strike a better balance between potentially conflicting human rights be better than a Religious Freedom Act? I would like to suggest some important ways to protect freedom of speech and employment and religion and speculate on other matters at the end. So I want to start with a question. Where is sex defined in law? Anyone know? No responses? 2 years ago, I asked quite a number of lawyers, both practicing and academic, and some of them very senior, and quite a number of politicians and a former Attorney General. They all said, I don't have a clue. And the answer is, nowhere in Australian legislation is it defined. The Americans have realised that this is a serious problem, and the US Justice Department is proposing to define sex in federal law, and this paper explains why. Biological sex defines science by reproductive function. The female gestates the offspring, the male impregnates the female. This is the only variable that serves as the fundamental and reliable basis for biologists to distinguish the sexes of animals is their reproductive role, and it's not some other behavioural trait. Although over 99% of people are XX female or XY male, there are variations. There are some XY people with a disorder of sexual development, commonly known as intersex, where the Y chromosome is dysfunctional and the person becomes female in utero, more female in physical characteristics than most XX females. Most intersex people, very small in number, identify with their sex recorded at birth, while a small number identify as the opposite to their birth sex. The point I'm making is, it is from the Intersex Society of North America. Intersex is not evidence of a third sex or gender, as is created by the transgender lobby, claimed by the transgender lobby. That humans are male or female is a belief held by the vast majority of people. It's a religious belief, as from the scriptures that says God created them male and female. And it is also a scientific and secular belief held by most people that humans are male and female. Opposed to this biological worldview, as I call it in this book, or belief, is the transgender worldview, or a belief, not from biology, but from the social sciences, that a person can change, ignore their biological sex, and should be legally able to self-identify with their own socially constructed gender identity. In March this year, the Tasmanian Attorney General Elise Archer informed all members of the state's Legislative Council that proposals to the Parliament to remove the sex identifier from birth certificates would bring risks of serious unintended legal consequences. Advice provided by the Solicitor General was that changes would affect the interpretation of all Tasmanian legislation that has, as a criterion, its application, as a criterion of its application, the sex of a person. For example, she said, there are a range of statutes that require police full body searches to be carried out by a person of the same sex as the person being searched. This is likely to cause difficulties if the person to be searched is registered as non-binary, indeterminate, or by some other phrase used to indicate a person's perception of self neither entirely male or female. In those categories, the power of search is likely to be compromised or negated. Without being defined in law, the legal meaning of sex has been taken as self-evident, axiomatic. in the same way that marriage was taken to mean the union of a man and a woman until this was challenged by advocates for same-sex marriage. Under that challenge, the definition of marriage was codified into the Federal Marriage Act in 2004 until it was changed to include same-sex and transgender marriage in 2017. Our first legal document, our first legal identifier document, is our birth certificate, from which flow a cascade of rights that unfold over our lifetime. For example, according to our age, our age calculated from birth, we are entitled to state-funded education, family payments, unemployment benefits, old age pensions. From our recorded parents, custodial and inheritance rights flow. From our country of birth flow citizenship rights, voting rights, and entitlements or disqualifications from public office. Our birth certificate records our sex, from which flows an array of, and this is very important, rights, privileges, protections, and access to services. These are sex-based inherent rights. Schools, which school you attend, what medical treatments you need, what sport you're playing, etc. Now in 2013, the Sex Discrimination Act was amended and gave protected attribute status to gender identity and sexual orientation. And at the same time repealed the biological definitions of man as a member of the male sex and woman as a member of the female sex. The amendment inserted the definition of gender identity, incidentally, is almost the same definition as has just been passed by the US Congress in its Equality Bill. It says gender identity means the gender-related identity, appearance or mannerisms or other gender-related characteristics of a person, whether by way of medical intervention or not, with or without to regard the person's designated sex at birth. I've broken it into three parts there because it's in three parts. There's many problems with this definition. Sex is said to be designated at birth, just as parents designate or assign a name. Sex is not an assigned option, it is recognised as inherent. Secondly, the definition says gender identity means gender-related identity. It's a circular argument. It's like saying the definition defining a table as an object that's like a table. It doesn't mean anything. It's a meaningless statement. And yet this has been written into law. This definition allows for a person to be legally recognised as one of the 58 gender identities on Facebook, pangender, genderqueer, androgynous, etc., etc., or to be on a spectrum of 100% male to female, so I could be 80% male, 20% female. Every person in this room could have their own unique position. Every person on Earth could have their own unique position on that 100% spectrum. Or to change their sex. A biological man can self-identify as a woman can self-identify as a man with or without sex change surgery. Whereas sex is objectively determined, gender identity is a subjective, wholly social construct. The Act specifies no minimum age for a person to adopt a gender identity different from their sex, and the threshold for legal recognition of a change of sex is low, requiring only a statement from a registered medical practitioner or psychologist, a passport or Australian government travel document, an amended birth certificate, or any state or territory gender recognition certificate or recognised detailed certificate. These are as easy to obtain as a flu shot from your local GP. Writing in 2014, Theodore Benedict from the UWA Law School said that while supporting the Sex Discrimination Act changes, he recognised that recognition of a person's sex, not their gender identity, is still extremely important for numerous reasons. A non-exhaustive list of 16 areas of sex where sex-based rights, privileges, protections and access to services are important include determining which school your child attends, access to sex-based sports, access to bathrooms, toilet showers, change rooms, access to school and university dormitories, homeless shelters, insurance, employment placements in sectors such as the military, providing safe spaces, comfort, protection, particularly for women against assault and rape, affirmative action policies including education, scholarships, jobs, pre-selection to Parliament, other forms, formal and informal affirmative action policies to counter discrimination based on sex, national security, protection against fraud, government planning, provision of services, acute monitoring of the sexes in public activities, monitoring of the sexes in public activities, promoting procreation, particularly in relation to marriage and medical research. To which I add in my book, recognition on birth certificates, identification on official documents, school registrations, Medicare, taxation, passport forms, prison accommodation, services to weddings, same issues there as for same-sex marriage, marriage counselling services, medical treatments, language and use of pronouns, psychological counselling, you counsel a person who's trans as male or female, lesbian and gay only specific organisations. To this you can add a number of things the Tasmanian Attorney General stated. Areas like police body searches or abortions in law only for women, not for trans female to male. Once gender identity is defined in law and a man can self-identify as a woman, then you have situations like Martina Navratilova referred to earlier this year, when she said men can self-identify as a woman for a period of time, play in the women's tennis, receive the accolades and the money, then revert to being a male and father children. Under affirmative action policies, it means men can self-identify as a woman and claim positions, for example, in the Labor Party that are reserved for women under affirmative action policies, or claim jobs reserved for biological women. It means men who are self-identify as women, and some of the most dangerous men on earth are claiming to be such as that, and in prison are being transferred to women's prisons, and there's cases where they've raped the women in those prisons. How do you determine medical treatments? There was the sad case last week of a Canadian person who was unconscious, I think, was taken to hospital, was a female to male, and they assumed this person was just overweight, not realising this person was actually pregnant and lost the baby. I speak to a trauma nurse who says to me, we need to know when a person comes in unconscious exactly whether we're dealing with a male or female, and therefore what particular treatments are needed. I want to make this clear. Almost all conflicts between the two worldviews cannot be resolved to the satisfaction of people holding one or other worldview. There is no resolution to these conflicts. And further, the conflicts created by gender identity being made a protected attribute are far wider than over sexual orientation and same-sex marriage. In my book, I have two tables on this and do the comparison of the conflicts over same-sex marriage. There are far more over writing gender identity into law. And the easy way to explain it is this. Gay boys don't use the girls' toilet showers and change rooms. Trans boys do. Further, nobody has yet comprehensively done the research to identify all the areas in which defining sex determines rights, privileges, protections and access to services. If there's any student doing a PhD, this would be a great PhD to do. Let me turn to schools. To comply with the amended Sex Discrimination Act, at least 4 state education departments, New South Wales, Victoria, Queensland and South Australia, have issued policies requiring state school authorities to negotiate with transgender students as to which toilets and other facilities and services they can access at school. Effectively, a boy can self-identify as a girl and gain access to a girl's toilet, showers, change rooms, sports camps and dormitories. The New South Wales policy is set out in a Legal Affairs Issues Bulletin number 55, assessed the risks in 9 out of 11 policy areas as high and the other two as median. As a person I know who is a child protection officer, the school said, what government department in their right mind would issue a legal bulletin of high-risk policies that have to be implemented by schools for children? The risk for the use of toilet showers and change room was rated as high, suggesting that other students may not face just discomfort but potentially more serious issues. So risk management for them involves doors provided to change rooms and cubicles, students must change in a cubicle, staff to monitor length of time, staff to report incidents, zero tolerance of skylarking. Are teachers to be rostered outside toilets? What happens to a male teacher's reputation if he finds it is necessary to intervene? Following the Royal Commission into Child Sex Abuse, about incidents in certain institutions, teachers may feel inhibited entering change rooms to monitor the length of time in a change room. These requirements come at a time when the community is very concerned over child-on-child sexual abuse. South Australian policy warns principals and teachers that failure to provide transgender students with access to appropriate toilets and change rooms facilities may breach anti-discrimination legislation. This means that school authorities could face legal penalties for non-compliance with these policies and disciplinary action, loss of professional qualifications and employment. What are the rights of parents to expect a duty of care? What are the rights of students to privacy? Currently, the Sex Discrimination Act provisions apply only to state schools. However, proposals by the Attorney-General to the Australian Law Reform Commission are to limit and, if possible, remove exemptions for faith-based schools while introducing other legislation, they say, to protect freedom of religion. But the straight removal of exemptions, and I do warn people here, would see the full force of the Sex Discrimination Act imposed on faith-based schools as I've just outlined. When the transgender worldview is imposed on society, it threatens legal penalties and loss of employment for those who don't comply. In 2015, Canadian psychologist and sexologist Professor Kenneth Zucker was stood down from Toronto's Centre for Addiction and Mental Health. Now, he is quite a famous man. He headed the American Psychiatric Association's committee that wrote the section on gender dysphoria for the diagnostic manual on mental disorders, the DSM-5. And he supported use of hormones for teenagers, but said there should be a watch and wait approach, particularly for younger children, until they grow up, because most of them, when they are adults, do not identify as transgender. And yet he was dismissed. Then there was David McCarrath, a 55-year-old who worked as a doctor for more than 2 decades, had his contract terminated with the UK Department of Works and Pensions in Dudley for refusing to address transgenders with gender-neutral pronouns. He was said to be non-compliant with the UK Equality Act. In McCarrath's case, he expressed a religious belief about the nature of human sexuality. It was a religious belief. In Professor Zucker's case, he had a belief about the provision of services over the appropriate treatment to children. As best I know, he's secular, he's not religious. Both had beliefs that were considered to be in conflict with the transgender worldview and suffered loss of employment. I'm going to skip over a little bit here, and if anyone wants to ask me later about Rugby Australia, I'd be happy to say a few comments about what's happening there as well. When laws recognise, as I said, when laws recognise a person by the gender identity and make gender identity a protected attribute, inherent sex rights are replaced by created gender identity rights. The conflicts are over biology and incidentally about religion. But we get caught with it. They are deep and unresolvable. A person is now recognised by their gender identity, the place of their sex in the Sex Discrimination Act. and Territory Anti-Discrimination Acts, on birth certificates in the ACT, South Australia, Tasmania, because they've altered their Birth, Deaths and Marriages Registration Acts to go gender fluid, and in the Marriage Act as recognised to recognise both same-sex marriage and transgender marriage in the 2017 changes. Very important to understand, this comes from an ideology, and this is the legal framework they're putting in place, a legal framework to impose this ideology on everyone, in the interest of a minority, and in the process threatening belief, freedom of religion, belief and employment. So, are there solutions? I'll offer a few comments and one significant suggestion. Some have called for legislation to guarantee freedom of speech and association. Assuming a new law would mean a school principal could say without detriment, I believe that a person's sex is fixed and that biological boys and girls should only use the appropriate sports and so on, how would such new freedom of speech laws also protect the principal from prosecution and loss of professional qualifications and employment under a Sex Discrimination Act compliant State Education Department policy that says if a boy identifies as a girl, the principal must allow the biological boy to use the girls' change rooms in sports. The difference between speech and what you actually are required to do. Freedom of speech may be protected under freedom of speech legislation, but will employment be protected? Secondly, neither a Religious Bill of Rights, Religious Anti-Discrimination Act or writing Article 18 of the ICCPR into Commonwealth laws would necessarily resolve the conflict between two worldviews, so long as gender identity remains in the Sex Discrimination Act. Even if a Religious Bill of Rights, etc., were to define man, woman and sex, uncertainty would remain. Would a person's rights be protected according to their sex-based rights under the law, or according to their gender identity under the SDA? I'd like to suggest that a solution, similar to what the Americans are proposing, is to go right down to the core of this. Look at the conflicts between the two worldviews and define in federal, state and territory laws, because they've got different coverage, particularly in anti-discrimination laws, or in any freedom of religion act or whatever, that man means a member of the male sex, woman means a member of the female sex, and sex is defined by reproductive function. That's getting to the core of it. And what that covers is not only religious people, but secular people. You know, Mark Latham says, I want to be protected and I'm secular. I don't want this forced on my kids. So that protects everyone. That's 90-something% probably of the population who recognise people by the biological, not the transgender worldview. There's two scenarios here. Scenario A, if these definitions replace gender identity in law, it would protect the inherent rights of the vast majority of people, religious and secular, who regard their birth sex as immutable. It would protect a person's freedom to speak and protect employment when, for example, a school principal said, I'm not allowing biological boys into the girls' change rooms and so on. Is that 2 minutes, is it? Scenario B would be to write the same definition beside gender identity. Now, in the Sex Discrimination Act or whatever. That would lead to eventual court cases and so on, but maybe that's what's needed in terms of the educated process of waking people up to this. And Nick Aroney and Patrick Parkinson have also proposed changing the definition of discrimination such that difference is not discrimination. I do give a bit of a warning to people about removal of exemptions from the Sex Discrimination Act. I know they're thin, but the reality is they do carve out a certain range of freedoms. They are conditional, but they are there. And to lose them and have inadequate protection from any other legislation would leave us in a worse situation. In short, my opinion, and it's only an opinion, I'm not a judgment, I'm throwing up for discussion, would be that any other the exemption should stay there, and what should go in is a new. If there is other legislation, it should reinforce it. Those exemptions. In conclusion, a tolerant democracy remains an open public square in which all beliefs, religious and secular, can be held and manifest. Or if there is an established religion, the state does not discriminate against other religious beliefs. When the state makes gender identity a protected attribute, it effectively imposes gender-neutral language, toilets, change rooms, sports on everyone, and hence the title of my book, Everyone's Made Same, One Shade of Grey. This is not diversity, it's uniformity. Secondly, I draw an analogy. Imagine if there was an Anti-Discrimination Act that said you can't discriminate against Catholics. It would mean state schools be forced to teach the Catholic faith, atheist organisations forced to employ. Effectively, the government would be imposing it as a new form of established state religion. This marks a return to the sort of state-imposed beliefs that resulted in the horrendous wars of religion, the wars of all against all. It marks a shift from a tolerant neutral democracy to an authoritarian state imposing one belief on all. For this reason, I urge you to study and understand both the state-established belief or ideology, this transgender worldview, because it's an ideology with a framework that's working. And we don't want to just attack it piecemeal. You've got to understand the core of it and then respond to it at its core. That's why I said go and define the definitions of man, woman and sex into law. They're axiomatic. Do it like we did with marriage. The framework, they have a framework of laws used as a concept as a mechanism to oppose on this society, attacking freedom of religion, freedom of belief and speech, and work out the political and legal mechanisms for resisting this new authoritarian temptation. And that is the purpose of my book, which is available today.